Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which I think will be of great interest to people who study jurisprudence, for the wider legal community, and for anybody involved at a slightly higher level with the whole work of statutory interpretation. The book I'm looking at is called The Coherence of Statutory Interpretation, and it's been edited by Geoffrey Barnes. It's a collection of essays from various people, experts in their own field, and the book has been published by an Australian publisher called the Federation Press. And I've given a title for our book review, this: A Useful Statement on Statutory Interpretation for All Commonwealth Jurisdictions. And that's, common law, I should say, jurisdictions. Obviously the Commonwealth are very much part of this, but it's really to cover those areas that practice the common law tradition where you have the need for statutory interpretation of statutes. I found it a very interesting book, and it's a question on statutory interpretation which is frequently in just about every single law exam paper you can think of, one area or another. So it's an important area, and also in practice there's quite a lot that comes into play when you're looking at the actual meaning of certain words. Let's have a look at the book first. Anyway, there it is. It's a hardback, blue. There's very much the standard house style of Federation Press. There's nothing on the back. It's not a long book at all by any means. It runs to 240 or 250 pages. There's a short index at the back. Again, not particularly substantial. There is some case law, but most of it is actually obviously not UK or England and Wales, but it's much wider than that. Then there's a detailed bibliography at the back as well, which is very helpful because it's a very substantial work in its own right, and the words are referred to in various chapters, so obviously it gives you a number at the end sometimes and tells you where you can find the reference to the specific detail. The front of the book, if I just show you that, there's the front of it there. Geoffrey Barnes is from the Trobe University, I should say, in Australia. There's a preface which is well worth reading, and I've borrowed some of what he said in the preface for this review. There's the second part of it, and he pays tribute to the people who've written the work, the various essays. Then the 10 parts. You've got 10 parts in total, with the names of the people on each of the individual parts. Then the contributors themselves, 17 of them, are listed. Some of them well known, probably to you. And then you've got a table of cases there. Some of the usual suspects are there, I hasten to add. Then you've got some statutes, again quite useful. Obviously these are very much to do with Australia, but you do have UK statutes. Then you've got part 1, the introduction. You can see how that runs. Then the opening remarks, and then the name of the person. You've got footnoting as well, and then you've got the body text. And that's how the book basically runs through. And it's been published, again, as is the case with Federation Press, on really nice paper, which is nice to touch and nice to handle. And I have to say, I think that does make a little bit of a difference. Some of the books are actually of not quite such good quality paper, and you've got to get into the feel of the book. Can mean quite a lot, believe it or not. Some people don't agree with that, but I think it does. What do we say about the book anyway? We say this book is, as the title suggests, probably not for the uninitiated common law practitioner because of its depth, because I did find it a detailed book, and you have to have some knowledge about what is being discussed here. However, I think it remains a valuable commentary on how we value statutory interpretation today. The editor is Dr. Geoffrey Barnes from La Trobe University, and he reminds us at the outset that, quote, legislation is a principal tool of government, unquote, whose reach is wide, covering areas from social welfare benefits in one area, say, to the regulation of road traffic matters in another, just to give you such a wide coverage of the areas involved. Now, this book, The Coherence of Statutory Interpretation, is published by the Federation Press. It's a book that has an international appeal about it. I certainly thought that when I looked at the title and started getting into the book itself, because what you've got here is Barnes has written that interpretation greases, an interesting description, the wheels of statute law's diverse operations, and he concludes that statutes depend on the law of interpretation not only to solve ambiguities, but also silently when the law is clear, citing as his justification for this an Israeli jurist called Aaron Barak, who has the view that a text cannot be understood without being interpreted. An interesting statement and probably a bit of a truism. And that, of course, is where we come in as lawyers. For the benefit of this book is the problem we face when advising clients. In other words, the development of the law of interpretation has arisen case by case, ad hoc and higgledy-piggledy, to use the editor's words. And of course this area is not rule-like in form, and it does offer some flexibility and naturally a constitutional coherence, which is what I call the Barnes approach. Although of course he's just one of a number of contributors, but I think you get my drift. The book contains 10 parts, and they're individually written by 17 highly experienced and expert contributors, and the parts cover the following areas. You start with an introduction, then you have constitutional perspectives, drafting perspectives, overall method, the text and the limits of the judicial role, the legislative purpose, acts, interpretation acts, objects, provisions, administrative law, and finally, of course, the conclusion. And Barnes writes that the overall method section is the one, that's the way it's contributed, but it's the one I found most important, because I suggest the readers are encouraged to read it, because this is where his approach comes in, where statutory interpretation is defined by general interpretive criteria. And of course what Barnes does is he states that such criteria is, quote, when specifically manifested in particular contexts, it sort of exists, and it provides us with the possible indications of the intended meaning which it's giving. And it's a truism, I would suggest, to say that such features have caused a certain amount of angst amongst commentators. It's always bound to be the case in any event, especially with this area, which is very much part of not legal theory so much as general pure jurisprudence, as I would put it. And in addition, we found the jurisprudential device used here of the fictional case, that's Regina versus Ojibwe, I think that's pronounced, quite a helpful exercise, although of course satire used here with this particular case may not be to everyone's personal taste. Whilst I've not got it in the review, one immediately thinks of the Speluncean Explorers, which is a classic in American jurisprudence about the attitudes of the judiciary on the American Supreme Court, taking into account the Dudley and Stevens case, which is basically a factual case, which was then changed into a fictional set of circumstances to prove a particular jurisprudential case. And we've got the same sort of thing here, which I think is a good, as I say, I think is a good device. Of course, recent thinking suggests that the law and practice has methodology rather than a basis of a coherent, rather than that of a basis of a coherent theory. So you've got this argument of methodology versus a coherence of theory, if you like, because obviously he's got the word coherence in his title, but the issue would really be, is it actually about method or coherence? Now that's an interesting point in its own right, because to the delight of all jurisprudence, I would suggest, there remains no one answer. The reason being that a legal system depends, according to the author naturally, quote, on public confidence in the courts interpreting legislation in an objective, coherent manner. And of course that's the basic mission statement. Let me conclude by saying this. What we've got here is a book of essays which gives us a useful analysis of the structure and operations of the law of interpretation, and it also offers a determination of how coherent the law is, with the conclusions of whether it can be carried out and presented in a more coherent fashion. And I think again that is to the benefit of everybody, because Barnes shows us the way forward, and I think it will be of great benefit to legal researchers and those who examine the way our legal systems operate in the 21st century. So a very big thank you to Dr. Barnes and his team. And the publication date of the hardback edition is cited as at the 1st of January 2020. I'm recording this in the spring. There's the book again, and then the spine. Just open it in the middle. It's a light book, very nice quality book. Is there an overall method to interpreting legislation? That's the title, in the middle of the book. And what you've got here, you can see you've got the footnoting to justify assertions made there and there. You've got a lot of detail, quite a lot of quotes. I think they're quite useful to have various quotes from the judiciary and various other people. Again, you can see clarifying the interpretation and its relationship with the text. In other words, trying to put it in its, trying to get some realism into where we're going. Again, you can see why jurisprudence comes into this. And of course, we run all the way through. And again, you can see the footnoting. As I say, just to remind you, there's a short index. I think the index could have been a little bit bigger, perhaps, in some ways. Although I do think the book is very much a book for academics. If you're doing, for instance, reading for a degree at the moment, and you have to do jurisprudence, which many universities require, this is a book I think you should read. It's not a long book, and it's not a difficult book, but there are bits in it which you could perhaps quote by doing your extra research to get that elusive first. Anyway, thank you to Geoffrey Barnes, all at Federation Press, for sending me the book for review. I'm delighted to have done so, and good luck with putting the new views of jurisprudence forward for the 21st century. Bye-bye.